Glad to see we got some folks out on Friday. This is our last event of the year, so I hope you enjoy it. I know I'm going to. Part of what really makes me enjoy being in the Federal Society here is that we shatter so many stereotypes between the officer corps and the membership. And our speaker today is definitely going to shatter one of those stereotypes. He has been past president of the Massachusetts chapter of ACLU. He continues to serve there. Longtime criminal defense attorney, civil liberties attorney, co-founder, I should say, of the Foundation for Individual Rights and Education, longtime civil rights advocate, Harvey Silverglat.
Thank you. It's my great pleasure to be here. I think this may have been one of the few schools in the country I missed on my book tour back in the late 80s, the Shadow University. So it's a real pleasure to be here. I was originally going to speak about Lawrence Summers and his brouhaha at Harvard, but I decided that you can't really understand what happened with Summers unless you understand what happened just before Summers got there. The Summers incident has been widely publicized. The incidents prior to Summers' arrival have been widely suppressed. And so I am going to talk about those incidents leading up to Lawrence Summers' problems, and I think you'll begin to understand what he was facing and why he caved in his battle at Harvard with the feminists in his own faculty. This is, by the way, this talk is on the basis of all my own original research. Some was done by Alan Kors, my co-author of the Shadow University. Some was done by me. It's all well documented. If anybody has any question about the factual accuracy of anything I've said, send me an email. I'll mail you or email you a copy of the document that proves it. I've been writing since 1969, and I've never been sued for defamation for anything I've written in any of my books or columns. So rest assured that the fantastic tale you're about to hear is entirely true. Okay. And incidentally, I'm going to put this talk on my website, www.harveysilverglate.com, so those of you tempted to take notes don't have to. It will be posted on the website. The title of the talk is The Death of Parody, Tensions Between Academic Freedom and Harassment Codes at Colleges and Universities. When I co-authored with my friend and cohort, Penn history professor Alan Charles Kors, the book The Shadow University, and by the way, I gave Justin a copy of it. You can sneak into the library here. Published in 1998, and it's now out in paperback. We directed our attention to the relatively recent phenomenon of censorship, largely by the left, directed against the right on college campuses. Such censorship carried out most frequently by means of politically biased speech codes, more recently renamed harassment codes, and I'll get to that in a minute, was and remains aimed at, in the words of the censors, protecting, quote, historically underrepresented and disadvantaged groups, close quote, from harassment on the basis of gender, race, sexual orientation, and a number of other classifications. In practice, such censorship was used not against true harassment, as we have long understood it in the common law, with also a statutory meaning of harassment, but against speech that might make the listener feel uncomfortable or, as the jargon goes, unwelcome. The overwhelming portion of such censorship was aimed, as the Shadow University seeks to demonstrate, against speech that is clearly protected by any notion of academic freedom, and on public campuses, federal and often broader state constitutional guarantees of free speech. While our book contains some examples of censorship of those on the left, we predicted that since the political pendulum always seems to be swinging in this country, the increasingly deeply entrenched culture of censorship would one of these days begin to move against the left. And indeed, largely as a result of the terrorist attacks of September 11, 2001, followed by the amorphous and seemingly endless war on terrorism, we have begun to see more and more campus censorship in the name of patriotism. This confirms the Shadow University's thesis that once we cease looking at free speech as modal, that is, as a primary value in itself, and not just a workhorse to be used to haul a politicized or ideological wagon, we so weaken its support in times of social and political distress that we render it essentially useless over the long run. The worm turns, and while it has begun to turn in the world outside the campus, thanks largely to fear of terrorism and seriously restrictive provisions of the USA Patriot Act and other measures, it has begun to turn too on campuses. Hence, censorship has now become very much a bipartisan undertaking, with the traditional civil libertarian liberals and the libertarian conservatives, as well as a few others, engaging in a rearguard action, trying to fight back. And I just point out that there is a very interesting left-right coalition in this country that is fighting this campus censorship. My foundation, FIRE, the Foundation for Individual Rights in Education, does have support from both ends of the spectrum in this war. Now, I'm going to focus in this talk on two interrelated aspects of this problem, namely the assault on parody, that's P-A-R-O-D-Y, and the expanding definition of verbal harassment. These two concepts are related. I've chosen parody to talk about in order to get into the subject because I want to avoid, for purposes of this talk, dealing with the more subtle and difficult issue, which those of you who've taken constitutional law, and I understand it's a first-year course, so you'll all have had some familiarity with it, the difficult issue of restrictions of speech that may be beyond the protections of advocacy speech set out by the Supreme Court in 1969 in Brandenburg versus Ohio, which protected advocacy, even advocacy of violence, except for, to quote the court, advocacy that is directed to inciting or producing imminent lawless action and is likely to incite or produce such action, close quote. That's the limitation on speech under the First Amendment. But I want to restrict my comments to an area where the Supreme Court, and indeed the entire society, has long been clear that constitutional free speech protections apply without any doubt, without any hedging. It's not subtle. And that's the protection of parody as a form of political commentary and criticism. It's becoming increasingly clear that censorship of campus parody coming from the left in the last 25 years in the name of avoiding harassment of, quote, historically disadvantaged groups, close quote, now comes from both the left and the right, although directed at different targets. The anti-libertarian left, in its mirror image on the right, disagree about many things, but they appear to agree on the appropriateness of resorting to the age-old response of censors to uncomfortable speech. Shut up, they reason. I have written in substantial detail about two recent incidents of censorship at the Harvard Law School. One aimed at alleged sexual harassment, and the more recent incident aimed at purported racial harassment. This longer article, which expands upon the talk I'm giving today, can be found on my website, harveysilverglate.com, if you're interested in more of the gory details of this fantastic tale I'm about to tell you. In both incidents, the attempts at censorship were directed against what were absolutely clear examples of parody. Examples that, on the basis of utterly unambiguous Supreme Court precedents, decided by unanimous Supreme Court. Supreme Court isn't unanimous about that many cases these days. It was unanimous in all of these speech precedents. It's not in doubt. It provides the broadest possible protection for such speech in the real world, that's the world outside the campus. What one may say with complete immunity and impunity in Harvard Square of Cambridge, Massachusetts, which is the public square, one says in Harvard Yard, which is owned by Harvard, at the risk of one's personal and professional well-being, and that is a very sad comment on Harvard's culture and university culture in general, where speech is more restricted on the campus than it is in the rest of society. Historically, it's been the other way around. Here's the story, the first story. On April 4th, 1991, New England School of Law professor Mary Jo Frug was stabbed to death in the street in Cambridge. This ghastly murder remains unsolved. At the time of her death, Professor Frug was working on a comprehensive treatment of feminist legal philosophy. In the piece she was writing, she insisted that the contemporary legal system constructs women's sex and gender roles, and that legal rules and discourse, quote, permit and sometimes mandate not only the sexualization of the female body, but also its, this is a quote, terrorization, close quote. Her draft article was laced with expletives. After much dispute among the student editors of the Harvard Law Review, Professor Frug's piece, unfinished piece, was published after her death in the Law Review as a memorial to her, despite the fact that those opposing the publication insisted that the draft was a poorly written, vulgar, political treatise. 1 year after Professor Frug's death, the Harvard Law Review distributed its limited circulation annual parody issue. It's called the Harvard Law Review, R-E-V-U-E is the name of the annual parody issue. The review typically consists of parodies of articles published in the real Harvard Law Review the previous year. The 1992 review included a scathing parody of Professor Frug's work. The article was cruelly attributed to, quote, Mary Doe, comma, rigor mortis professor of law, close quote. You can imagine how that was received in the Harvard community. While references to Professor Frug's violent death were offensive and tasteless, at least in my view, meriting rightful criticism, the piece as a whole was in fact an unstinting criticism of the Law Review's somewhat politically correct decision to publish Professor Frug's unfinished draft. It seems more of an unabashed satire of radical feminist scholarship than a mockery of Professor Frug's death. However, reasonable people can disagree on this and see it as an utterly tasteless and cruel mockery rather than a serious commentary. I thought it was actually both. Most of the Harvard Law School community was never intended to see the parody. Nevertheless, and not surprisingly, the parody was widely leaked. Beginning on April 9, 1992, when 12 female law students distributed a pamphlet expressing outrage, the parody produced a growing torrent of increasingly angry, open letters. The president of the Harvard Law Review, the real review, wrote an open letter apologizing for the publication of the parody and stating that steps had been taken to respond to the, quote, crisis, close quote. The Harvard Law Review ceased all distribution of the parody issue and suspended its publication indefinitely. The authors of the parody penned a public recantation. The editors originally responsible for publishing Professor Frug's actual manifesto in the real Harvard Law Review, now apologized for not protesting the satire before it was distributed. Law School Dean Robert Clark wrote another open letter of his own, declaring that, quote, "The piece offends all standards of decency. The president of the review has indicated that steps are being taken to address underlying problems and attitudes," and I want to stress attitudes, "and I shall consider what further steps may be appropriate." This from the dean of the Harvard Law School. Dean Clark initially declared that the school would not punish the offense and said that, quote, "I agree with those," and I want to emphasize this, "I agree with those who think that the best response to offensive speech is not to curtail it forcibly, but to condemn it and explain why it is wrong." And I want to emphasize that was his initial response. If you want to understand Lawrence Summers' later 360-degree spin, shift, you have to understand the history of Dean Clark, who was, by the way, a conservative. He was brought on to the deanship in order to try to control certain leftist elements of the faculty. And you'll see now how he completely caved in his effort to protect free speech. Dean Clark's response did not satisfy those who were calling for vengeance, who eventually intimidated him into submission. Angered by what they saw as the dean's indifference to the incident, 9 law school organizations on April 16, 1992 demanded Dean Clark's resignation. 3 days later, Professor David Kennedy, still on the faculty, conflating the legally distinct concepts of speech on the one hand and action on the other, characterized the parody as a terror attack. That is a quote, as a terror attack on the lives of women. Quote, this is Professor Kennedy, "Many women experience the document's delivery as a direct threat of personal violence," close quote. You can call this parody many things, but I think it's a little over the hill, to put it mildly, to call it a threat of violence. Professor Kennedy went further. He asked the law school's Judicial Administrative Board to bring charges against the authors and the law review officials. He further recommended that the administrative board look into whether the authors and those in positions of authority at the Harvard Law Review might be morally disqualified from becoming lawyers. Kennedy's letter earned the support of a self-appointed review action committee. Professor Alan Dershowitz, one of the very few faculty voices publicly coming out in favor of freedom of expression in this imbroglio, wrote a syndicated column in which he sharply criticized the effort to bring disciplinary charges against these students. But Professor Lawrence Tribe, a leading constitutional law expert who had gained national attention by questioning Judge Robert Bork's commitment to liberty, publicly replied that, quote, and this is a direct quote from Lawrence Tribe, "The mutilation of Professor Frug's memory goes well beyond speech in any meaningful sense," close quote. One of the nation's leading First Amendment and constitutional scholars actually said that this parody went, quote, "well beyond speech in any meaningful sense," close quote. And I'm still waiting to hear from anybody in the Harvard faculty how this went beyond speech. Needless to say, nobody talks to me anymore about this. 4 weeks after Professor Kennedy brought his charges, the administrative board ruled that it could not punish the authors of the parody. But why? Because, quote, "no law school rule imposes limits on the content of publications by students that would be applicable here or empowers the administrative board to deal with such harassment, close quote. The administrative board's decision, in other words, rather than settling the issue on behalf of free speech on the basis of, and as a matter of academic freedom, became the catalyst for the law school's consideration of the adoption of a speech code. What the board essentially said was, well, if we had a speech code, it'd be different, but there was no rule they violated. 1 year later, Dean Clark appointed a faculty committee to consider adoption of sexual harassment guidelines. Professor Dershowitz himself accepted a place on the guidelines committee, reasoning that given the context, he would prefer to have clear, narrow rules restricting speech rather than unspecified, vague, and unwritten common law standards or understandings. I disagree with him on that. I suspect he may be changing his mind about that these days. But that was his position at the time. If you're going to have a rule, might as well have it in writing so it's clear. Only 3 professors on the faculty expressed outright opposition to such guidelines. 3 on the entire Harvard Law School faculty. The law school faculty passed one guideline that banned, among other things, and this is a quote, any speech or conduct of a sexual nature that is unwelcome, abusive, or has the purpose or effect of unreasonably interfering with an individual's work or academic performance, or creating an intimidating, demeaning, degrading, hostile, or otherwise seriously offensive working or educational environment at Harvard Law School. And I've been through 4 years of college, 3 years of law school, and I've spent time teaching law school. I don't think I've had a day on the campus when I didn't hear something offensive being said. I don't think it's possible to spend a day on a college university campus and not hear something that offends you. Occasionally you can go through a day in a prison not hearing something that offends you, but not on a college campus. The school added, and get this, a savings clause to the policy, exempting from punishment speech that would be protected by the First Amendment. In other words, you have the rule, there's all of this you can't say, but none of this is meant to infringe on anything would be protected by the First Amendment. This clause, however, was an illusory protection designed to encourage the misconception that students at Harvard Law had the same free speech rights as any member of the American public. As Professor Tribe himself had written in his leading textbook on the Constitution, American constitutional laws, quoted by the Supreme Court more than any other constitutional text, savings clauses, wrote Professor Tribe, are highly problematic because they deter conduct that is actually permitted. This is a quote from Professor Tribe's book explaining why savings clauses actually make speech worse, free speech worse rather than better. A law whose reach into protected spheres is limited only by the background assurance that unconstitutional applications will eventually be set aside is a law that will deter too much that is in fact protected. And if you're interested in his reasoning, I've got on my website the site for where in his book you'll find this. He's got a whole discussion, and it's absolutely true, that to have a very broad censorship law and then to say, but if it's First Amendment protected, it's protected, that actually deters more speech than if there were no rule at all. Professor Tribe, despite this, voted for the guideline. The Frug parody almost certainly would have been in violation not only of that guideline, but also the second guideline that the faculty adopted that forbade, quote, speech or combination of conduct and speech that would be viewed by a reasonable person as physically intimidating and that has the purpose or effect of unreasonably interfering with an individual's work or of creating an intimidating, demeaning, degrading, hostile, or otherwise seriously offensive working or educational environment at Harvard Law School. This guideline not only lacked even an illusory savings clause, but explicitly stated that, quote, though appropriately broad on a university campus, the right of free expression does not encompass the right to engage in abusive or intimidating conduct, close quote. Harvard's policy, just like the debate over this incident, betrayed a frightening confusion between speech and conduct, alternately referring to the speech, conduct, offensive, threats. None of these distinctions mean anything anymore, as long as what you say is unwelcome. Recall Professor Tribe's argument that the mutilation of Professor Frug's memory went, quote, well beyond speech in any meaningful sense, close quote. Recall Professor David Kennedy's charge that the authors had delivered, quote, a direct threat of personal violence, close quote. They simply do not understand, or pretend not to, at Harvard Law School any longer the difference between speech and action. In the year 2002, a similar contretemps broke out, but this time in connection with a student who misspoke on an issue of race in an abbreviation of a case posted to a discussion board. I don't have time to go into the details of this hysterical incident, but it is in the article on my website. In some ways, the racial harassment brouhaha was an even more serious affront to academic freedom than the Frug parody, for it resulted, get this, in 2 professors being silenced and punished for dissenting from the increasingly common belief that facially insensitive speech should be punished. Professor Charles Nesson took a semester's leave of absence from teaching, attending his own class as an observer rather than as the professor, with another faculty member and a member of the administration teaching the course for him. This happened at Harvard Law School. Professor David Rosenberg saw the dean inform students in his torts class that if any student found it too painful to attend his class in person, the classes would be tape recorded and students could cut the classes and instead listen to the tapes. Just imagine the insult to the women at Harvard Law School to insinuate that they don't have the fortitude to attend a torts class because the professor had said something that they found offensive. One's breath is taken away by this cowardly response to cries for censorship at the law school that produced such stalwart defenders of free speech as Holmes and Brandeis. Suffice it to say that it was the success in enacting sexual harassment guidelines directed at constitutionally protected speech that allowed the demand for racial harassment guidelines to gain steam and to be taken seriously. Only after considerable outside publicity and pressure did the law school allow this further demand for a racial censorship code to die a quiet death. However, the sexual harassment guidelines are still on the books, and the last time I checked, and I check often because I live a 10-minute walk from Harvard Law School, there have been no especially biting parodies at Harvard Law on the subject of either gender or race. And as the recent Lauren Summers incident points out, there haven't been any serious discussions about those subjects either. There's only one official point of view, and God help those who either mock it or dissent from it. This is not promising for a school that is training lawyers, judges, and leaders in other fields. The influence of a law school racial harassment speech code, however, will not end at Harvard's gates, nor even be limited to the academy. The academic Marxist theories of the 1960s and 70s discussed in the Shadow University, positing the view that true equality could be achieved only by the unequal application of speech rights to create a so-called level playing field found their way into college and university offensive speech codes in the 1980s. This is a precursor, by the way, to affirmative action. If you're interested in the development of how affirmative action came about, go back 20 years to Herbert Marcuse's theories, which are discussed in the Shadow University, in which he came up with this notion that if you want to make people who are in different social classes equal, you have to give them unequal speech rights. That is, you have to restrict the speech rights of those who are in the more advantaged classes and give extra speech rights to those in the disadvantaged classes to create a level playing field. These codes were all later declared unconstitutional in public campuses in the 1980s, but they gave birth to the next generation of such codes, which are the modern day federal harassment regulations enacted under the guise of civil rights laws, covering not only workplace but also campus speech that creates a hostile environment. Flying in the face of a fundamental principle of liberal education, these codes, which are in effect on virtually every college campus in the country today, assume that a campus of higher education can accomplish its educational and truth-seeking goals while simultaneously catering to those seeking and expecting an innocuously inoffensive educational experience, something that I think is absolutely impossible. You cannot have an innocuously inoffensive experience and think you've been educated. Now our universities have virtually all adopted similarly worded harassment codes, arguing speciously but effectively that they are obligated by federal law to limit such speech on campus. Let me read you a portion of Duke's codes. Protected Group Harassment Code. This is a quote. Verbal or physical conduct. You'll notice verbal. It's always verbal or physical conduct, as if saying something nasty is the equivalent of punching somebody, which may or may not be sexual in nature, that because of its severity or persistence interferes significantly with an individual's work or education or adversely affects an individual's living conditions. Sexual harassment code from Duke. Sexual advances or requests for sexual favors or sexual harassment when an individual's employment or education depends or seems to depend on submitting to the conduct. Sexual harassment can also be the creation of a hostile or intimidating environment through severe or persistent verbal or physical actions of a sexual nature. As you can see, the parody of Professor Freud would arguably be a violation of this code here. Sexual harassment can occur between equals, etc., etc. This symbiotic relationship between academia and federal regulators has produced an atmosphere of profound censorship and fear on our campuses, which will end only when the courts make it clear that these concepts are simply backdoor approaches to a desired end, restricting otherwise protected speech. And I'm going to give you a few very quick examples of various kinds of what I consider to be parodies or hyperbole on various campuses, which have recently been censored by college administrators. I'm going to give you examples from both the right and the left. These are all discussed on the FIRE website, www.thefire.org. In the fall of 2001, University of New Mexico professor Richard Berthold addressed the terrorist attacks on the U.S. in his morning class on Western civilization, remarking, quote, "Anyone who can bomb the Pentagon has my vote," close quote. The professor apologized for the statement, claiming that it was, albeit stupidly, intended to be a joke. At the very least, the comment seems hyperbolic. The university's president announced he would, quote, "vigorously pursue," close quote, "disciplinary action against the professor." The president later told the professor that he had violated University of New Mexico policy with his remarks, and the professor was banned from ever teaching freshman history again, a course that Berthold had taught every semester for 30 years. During 2004 and 5 school year, the University of Colorado and Boulder investigated an essay in which Professor Ward Churchill likened Americans killed at the World Trade Center on September 11th to, quote, little Eichmanns, close quote. Though the university ultimately produced a report that states that no action should be taken against him because his free speech falls within the protections of the First Amendment, the report went on to state there was sufficient evidence of other academic impropriety that existed in the work, and he remains under investigation. I have to tell you, I've read some of Professor Churchill's work, and I was shocked that he was granted tenure on the basis of the academic merits of his work. But having given him tenure, the university can't pull it back when suddenly its campus radical becomes inconvenient or too notorious. In the weeks following 9/11, Kenneth Harrelson, an associate professor of political science at Orange Coast College in California, was removed from his classroom for nearly 4 months for an investigation into a question he posed about why there was an asymmetrical response by Arabs to the attacks on the World Trade Center compared to attacks on Israel. He had posed the question in a class, and he got yanked for it. In the fall of 2004, at the University of Massachusetts, in my backyard, a group of student leaders threw a party at which they parodied the racism accusations lodged against them by a minority student organization after a hotly contested student election in which one of the candidates, a white, had been branded very unfairly, I can say, I've looked into this, as a racist. The party goers who had lost the election took photographs of themselves posing in front of a cartoon depicting the candidate dressed in Ku Klux Klan garb with a moronic expression on his face. Students offended by the obviously sardonic pictures put pressure on the school's administrators, who in turn forced the student government leaders to all resign their positions. In March 2004, at Occidental College, administrators, that's in Los Angeles, administrators fired a student, Jason Antevy, get this, from his position as host of a student radio program and found him guilty of sexual harassment for the satirical jokes he made on the air. Talk about harassment. You turn your radio on, you hear a satire, and you suddenly feel intimidated, and the student gets fired for sexual harassment. The university followed this action by dissolving the entire student government. Mr. Entebbe has now sued the college, and the suit is pending. In February 2005, the Dean of Students at Northeastern Illinois University, Michael Kelly, threatened to bring charges against the student political group that planned to host a bake sale satirizing affirmative action. At this event, the student group planned to sell baked goods at lower prices to non-white, non-male purchasers, a kind of ham-handed, but I think fairly transparent attempt to comment on the unlevel playing field established by affirmative action. 2 months later, after corresponding with fire, the university decided to back down and allowed the students to host the bake sale. This bake sale battle went on at least 6 campuses that fire is familiar with. We naturally won on every one of them because it's so obviously a parody and so obviously protected as a protest against affirmative action. As is obvious from these examples, college administrators have attacked speech on the left and the right precisely when it performs the function that speech performs at its most vital, when it dissents from prevailing views and orthodoxies. Now, this conflation of offensive speech with harassment, I'd like to, since you're law school students, I'm going to discuss briefly 3 Supreme Court cases that it seems to me, completely nails the coffin on all of these harassment codes as they apply to speech that is merely offensive. And I urge you to look at these decisions. They're remarkable. Remarkable, if for no other reason, that they were decided, all three of them, unanimously by the U.S. Supreme Court. My favorite, in a way, is the Hustler magazine versus Jerry Falwell case at 485 U.S. at 46 in 1988. In the early 1980s, well-known minister and social conservative Jerry Falwell sued his polar opposite, Larry Flint, the publisher of Hustler magazine, charging invasion of privacy, libel, and intentional infliction of emotional distress. This arose from, as the Supreme Court delicately described it in its unanimous 1988 decision in favor of Flint, a parody published in the November 1983 issue of the magazine in the form of a mock interview in which the good Reverend disclosed, quote, that his first time was during a drunken, incestuous rendezvous with his mother in an outhouse, close quote. The Hustler parody, said the Supreme Court, quote, portrays Falwell as a hypocrite who preaches only when he is drunk, close quote. The trial judge had thrown out the privacy claim, submitted libel and intentional infliction to the jury, and the jury found in favor of Falwell on the intentional infliction of emotional distress claim. And the case went to the Supreme Court on the question of whether this insult to Falwell, which was obviously a parody, could be actionable as a tort, intentional infliction of emotional distress. And the Supreme Court took the challenge on directly. The court held that parody is meant to be hurtful, and it's precisely why it needs and enjoys full constitutional protection. One of the lines in the opinion, the appeal of the political cartoon or caricature is often based on exploitation of unfortunate physical traits or politically embarrassing events, and exploitation often calculated to injure the feelings of the subject of the portrayal. We have a constitutional right in this country to insult people. The art of the cartoonist is not often reasoned or even-handed. It's slashing and one-sided. The implication of this ruling alone for these harassment codes, it seems to me, are obvious. The issue came up in a different context in another case in 1985. This was a case that the Seventh Circuit decided in a masterful opinion written by Judge Frank Easterbrook, who's often mentioned as a Supreme Court, although he's now getting a little old, Supreme Court material. He wrote the opinion in American Booksellers Association versus Hudnut, 771 Fed 2nd at 323. The city of Indianapolis had enacted, believe it or not, and enforced an anti-pornography ordinance that claimed that it was protecting women's subordination. Remember, pornography is constitutionally protected. Obscenity is not. Pornography is. They figured this is a backdoor for getting rid of pornography, Playboy magazine type, softcore stuff. It provided for a civil damages action by women who were injured by the attitudes engendered by the magazines. Judge Easterbrook saw through this as a veneer of a civil rights law, described it more accurately as an effort to coerce a change in attitudes, noting that supporters of the ordinance say it will play an important role in reducing the tendency of men to view women as sexual objects. He concluded that it faced an insurmountable constitutional obstacle. It not only sought to alter attitudes, but it did so in a manner that discriminated by viewpoint, favoring only speech treating women in the approved way, sexual encounters premised on equality. It was the preferred viewpoint. And what the court said was that this is not the role of government. The City of Indianapolis appealed to the U.S. Supreme Court, which accepted the case for review and found the issue so clear that it summarily affirmed without the need for oral argument Judge Easterbrook's and the Seventh Circuit's opinion. This is a rather rare occurrence when the Supreme Court sees a case so clear that it doesn't even call for oral argument. It's summarily affirmed. And this whole notion that attacking free speech as a civil rights measure to protect somebody's civil rights is a non-starter. And the third example is from my backyard. Supreme Court dealt with another clever but futile oblique attack on free speech under the umbrella of civil rights laws. It involved a contest between the South Boston Allied War veterans, led by one John J. Wacko Hurley. Everybody called him Hurley. The Supreme Court, everybody called him, in Boston called him Wacko. He called himself Hurley, Supreme Court case. And the Irish-American Gay, Lesbian, and Bisexual Group of Boston, GLIB, GLIB, which was formed for the purpose of marching with a gay rights banner in the 1993 annual St. Patrick's Day parade case in Boston, which is, by the way, a very conservative, family-oriented, kind of old Irish institution. They were not happy at the prospect of having a gay rights group marching under its own banner. And I should point out, I know it's getting late, I'll be about 5 more minutes, point out that the crux of the problem was not whether gay people could march in the parade. Gay people could always march in the parade. It was the holding of the banner. The state courts had sided with GLIB and arguing that such a parade was a public accommodation, much as a hotel or a railroad station, that anybody had access to it. The Supreme Court decided that no, it was not a public accommodation. It was an expressive event, and as such, the veterans had a right to express their point of view in their event. If the gay Irish Bostonians didn't like it, they could hold their own parade and without forcing a change in the message of the main parade. So we have these 3 cases, Falwell, Hudna, and Hurley, and all of them decided unanimously. It seems to me makes it absolutely clear that these speech codes simply cannot stand. Now let me conclude with an example that I hope will make your hair stand up. It used to when I had hair, it made mine stand up. And this is an absolutely true case in which I participated as a lawyer for fire. And that is the case of Professor George Fletcher of the Columbia Law School. 1999 class at Columbia. The Cardozo Professor of Jurisprudence, George Fletcher, a renowned criminal law specialist, asked a provocative hypothetical question on an exam in a required law school course. The question, which was based upon facts gleaned from actual cases, presented a hypothetical scenario in which an anti-fertility cult activist attacked 3 pregnant women. The question drew the ire of some people in the law school community because one of the women in the hypothetical who was attacked and who aborted her fetus from the attack told her doctor that she wanted to write a thank you note to her assailant because she in fact had wanted an abortion but was having difficulty obtaining one due to the advanced term of her pregnancy. The dean of the law school, David Lebron, wrote Professor Fletcher that as a result of the complaints the dean had received regarding the exam question, the dean was, get this, required by the law to consult with University General Counsel on the question of whether the exam constituted a form of sexual harassment. In a subsequent response to Professor Fletcher's inquiries regarding his academic freedom to ask even a provocative question on an exam, Dean Lebron wrote, quote, "The suggestion that one of the victims wanted to thank her attacker is both preposterous and revealing." Again, it may, I want to emphasize, it may be that this falls within the rubric of academic freedom, maybe, but an examination in a large course is a public act, and the same notion of academic freedom allows students and colleagues, including me, to express views on that exercise of academic freedom as it affects members of our community. Of course, what the dean was doing was not expressing views. He had commenced an investigation of the professor on the issue of whether or not the exam was harassment or whether it was protected by academic freedom. Deans have a special way of expressing their views. They investigate. In a letter to the dean, I noted that, quote, the notion that the exam may be protected is very disturbing. Surely the exam is clearly protected, I said. In the end, the dean dropped the investigation of Professor Fletcher. At some point, all of us are going to have to tell college and university administrators and their general counsel what the then dean of the Columbia Law School finally understood after much back and forth discussion and arguments. When someone in the campus community utters words and ideas that some find offensive, but which under no stretch of the imagination constitute a real threat or otherwise fall into a traditionally prohibited category of speech, then there is not only nothing to prosecute, but there is nothing to investigate. These are not, or at least in a free country should not be, close cases or difficult cases. I'd be happy to entertain questions about these, or if you want, how the predicate for what happened at Harvard explains the retreat of Larry Summers when he, in a public speech, actually it wasn't really a public speech, it was a semi-private speech to a small group of scholars, suggested the possibility that underrepresentation of women in the sciences might have something to do with a genetic differences between men and women's brains. Not that men are smarter or women are dumber, but that they have different facilities. And the firestorm was such that he ended up not only backing down, but allocating $50 million over 10 years to increasing the representation of women in the sciences at Harvard. Why did he back down? Well, look what happened to Dean Clark. There's a history of any attempt to be sensible, and not only sensible, but to affirm the values of academic freedom and free speech, meets with such a barrage that no administrator at Harvard in my lifetime has had the guts to stand up and say, hey, wait a minute, these principles are hundreds of years old, and they're very clear, and we're entitled to hear people's true views on these subjects and not legislate against them. In any event, I will entertain. I've talked long enough. Yes.
I wonder if you could talk more about the second incident where I heard about it over drinks at a bar once, about what the academic responses were. As there were these two sides of the racial incident, and one was I guess there were professors responding in class, and how that led up to Summers' problems. What they were.
You're talking about the Summers problem you're talking about?
Before. The one previous to Summers, Nissen or?
Oh, Nissen.
No.
Yeah, I mentioned, yes. That's the most remarkable thing. Professor Nissen, he's a fabulous teacher. He's a creative and inventive teacher. And he saw this as what he called a teachable moment. And he wanted to have a mock trial of the student who had made the racially offensive comment. And he, Nissen, wanted to be the attorney in the mock trial to represent the student. And he wanted someone else to be the prosecutor. And he wanted to have the student prosecuted under traditional harassment code law, and have a mock trial in order to elucidate these issues. The distinction between just what I've been talking about, where does academic freedom and free speech begin, and where does a real offense begin? I don't, when I say offense, I mean violation begin. and for having the nerve to suggest that there should be a mock trial based on this rather than a summary execution of the students. The students, not all the students, just a few students in his class reported him to the dean as having not taken this seriously enough. And the dean, now, how much Nesson volunteered not to teach his class for a semester and how much the dean insisted is the subject of confidential conversations between Nesson and the dean. I happen to have some inside information about that, which I will not disclose to you because it was given to me in confidence. But think about whether or not you think a tenured professor at Harvard Law School would on his own volunteer not to teach his class for a semester, but instead to sit there in the front row while two other professors, one of them being an assistant dean and one of them being on the faculty, teach the class for him while he's in the front row. It was obviously humiliating. It was a devastating blow to academic freedom. All done because some students in the class found offensive his making a teachable moment out of this incident. Professor David Rosenberg, friend of mine, made a very stern stuff. David Rosenberg would have none of it. David Rosenberg's comment to his torts class, he was being critical of the critical legal studies field. And some of you are probably familiar with it. It's a kind of a leftist Marxist interpretation of law that we talk about a little bit in the Shadow University. I happen to find it, just barely short of the absurd. Other people make whole careers writing impossible to understand law review articles on the subject. But David Rosenberg made a statement that neither the critical legal studies, critical legal women's studies, nor race studies have made any contribution to any subject in the law, including torts, which was what he was teaching. And the way it came out was neither the women nor the blacks have made any contribution to torts. It's obvious from the context, because he was talking about critical legal studies, he was talking about women's critical legal studies and black critical legal studies. 3 students in the class interpreted as a racial slur on blacks in general, was clearly not, and reported him to the dean. There were inquiries made. Rosenberg refused to not teach his course, basically challenging them to try to force him. They backed down. He continued to teach his class, but the dean issued this insulting, counterproductive, ludicrous edict that if there were any students in the class, blacks or women, who would be so pained to show up in a David Rosenberg class, they could skip the class and listen to the tape recording. And it seems to me that's just barely short of what was done to Charlie Nesson. It was more of an insult to academic freedom than it was to Professor Rosenberg, who couldn't give a damn and continued to teach his course. But I can tell you that David Rosenberg is a very rare bird. I think most professors would have been terrified and would have, in order not to insult the students, would have become a student in his own class and not taught. This happened to Harvard Law School, and it was not widely publicized. I suspect none of you have heard the story. It should have been front page New York Times. It wasn't, of course. It did eventually appear in an editorial column in the Wall Street Journal because I took the journal off about it. But it's remarkable, you think about it. And so, these things happened. You understand that it was virtually predictable that Larry Summers was going to fold. Every Harvard administrator who had to take on the radical race and the radical gender lobbies has backed down. Nobody's had the guts to stand up for academic freedom at Harvard in a good 25 years. Another question? Yes, in the back.
So what do we do about it?
Exposure. after the Harvard Law School sexual harassment guidelines were passed. Now, this was all done in secret. I, who have my ear to the wall at the law school, I, who live in Cambridge, 10-minute walk from the law school, didn't realize this was happening. And before I knew it was happening, the faculty had approved it. I wrote an op-ed, which I got published in the Wall Street Journal, and exposed what had happened. A friend of mine told me that Dean Clark was overheard, absolutely furious when the piece appeared in the Wall Street Journal, saying he wouldn't have minded if Silverglate wrote a law review article on this, but to publish it in the newspaper, read by all of his donors, was outrageous. That gives you an idea of how to fight this. It is essential that alumni learn what's going on, that the parents of students learn what's going on, that the students learn what's going on. Because they can only operate in the shadows. If the Harvard Law School faculty meeting that adopted the guidelines were published on, were on C-SPAN, it wouldn't have happened. Because they wouldn't have had the nerve to vote for a censorship code at the law school. As long as they could do it in secret. I was telling Justin earlier today that the law school, one of the things that happened at the law school, there is an independent student publication called the Harvard Law Record, student edited, student financed, and very independent. And they have editorials about these things all the time. About 4 years ago, the law school started to publish its own alumni magazine for the law school called Harvard Law School Today, and it's just a propaganda rag. But it's nicely put together, it's glossy, and it goes out free to all living, and I suppose some dead, Harvard Law alumni. Needless to say, it significantly cut into the circulation of the law record for which you get charged. And I don't have any doubt that it was the dean's way of trying to put the Harvard Law Record out of business because they do not want an independent student newspaper that constantly is blowing the whistle on what they're doing, especially to their alumni. The Law Record is still holding on, but it's having a much harder time. That's the way to get them, through publicity, as Dean Clark said, in the newspapers read by the donors. And so FIRE, for example, our single biggest weapon of publicity. We have relationships with a couple of thousand newspaper and TV reporters all over the country. And the thing that gets deans the most upset when they hear from us was, we know the reporter or the editor of the local town paper, as well as the largest newspaper in the state, as well as every major national news outlet. And we will make sure that what the dean is doing gets publicized locally and nationally. They can't do in public what they do in private. And therefore they back down. Almost every time they back down. Exposure, sunlight, as Justice Brandeis said, is the best disinfectant. And that's the way to win this war. We do some litigation. We have a speech codes litigation project. We have won every case we've brought. These speech codes are all unconstitutional. It is not a close call. One of the best opinions written, by the way, was Judge, perhaps soon to be Justice Alito, in a Third Circuit case in which he invalidated a school system's harassment code, explaining eloquently why these codes simply can't exist in the face of the First Amendment, a case called Sachs, S-A-X-E. And we do win all these cases because it's so clear. But litigation isn't enough. First of all, private schools are not bound by the First Amendment, so you really have to use a moral argument against them. The only way a moral argument works is if it's highly publicized, and that's the answer. Become a whistleblower. They can't take it. They can't take light and they can't take heat. All they like to do is take credit. Another question. Looks like we're close to the end, yeah.
Is there any version of a speech code that would pass? In other words,
Yes, I could write a speech code that would be constitutional.
Well-
And it would be very simple. It would essentially adopt the common law definition of harassment. For example, if you call somebody up at 3 o'clock in the morning and you say, I hate you, I hate you, I hate you, and you do that 3 o'clock on Monday, and 3 o'clock on Tuesday, and 3 o'clock on Wednesday, and you call the person names, you bitch, you blah, 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 blah. You are harassing that person. But why? Because of the time, place, and manner of traditional tort law. It is not the right time, it is not the right place, and not the right manner to tell somebody you hate them. You only have to tell somebody you hate them once. And you do that during regular business hours. And then they've gotten the message. Anything beyond that could be harassment because of time, place, and manner. And to prove, and it's completely viewpoint neutral. If you call someone up 3 o'clock in the morning every day and say, I love you, I love you, I love you, it actually is more common than the people who call up and say, I hate you. That's harassment. You can be indicted and convicted for it. That's traditionally what verbal harassment has been. Or threats. I'm gonna kill you, I'm gonna kill your dog, I'm gonna put a sheep's head in your bed. That's harassment. But harassment is not saying something that gets somebody upset, because that is the normal parlance in a free society. We do it every day. I dare say, I don't always talk to, I consider this to be a fairly receptive and friendly audience. I hardly just talk to friendly audiences because my goal is to change people's minds. I've spoken to conventions of school general counsel, talk about going into the lion's den. So a lot of them were very offended by what I said about general counsel. I had some very harsh words about general counsel who are not really lawyers. They're administrators much more than they're lawyers. They lose their faculty, their reason, their ability to reason once they become members of the administration. Legal thinking goes out the window, and administrative convenience governs what they do. I gave an offensive lecture to them. Some of the questions they asked and comments they made afterwards were equally offensive to me. But that's this country, We don't have gulags for people who offend. And you listen to a debate in the Congress anytime, and you got to be offended at least 4 times an hour.
What I'm thinking of is, when I was in Georgia, one of the things the professor said once was that he was talking about a case where a woman was injured, and she was injured physically. And the main problem for her, he said, was that now she had trouble getting married, which is all she really had. And I'm picturing things like that happen a lot, and where students have to show up to class.
Mm-hmm.
And the administrators obviously have some interest in not having people upset all the time when they have to do these classes, even if it's there's an overriding academic freedom argument. Is there anything they can do other than talk bad about the person, that is fight speech?
Well, yeah, because there are standards for teachers to meet. Now, the comment that you just made, if it's sort of an isolated comment, seems to me the response of the student should be, well, then how did you get married? And then the professor would, perhaps he would try to punish the student for saying that, and then the issue would be joined. The professor would, of course, lose. There are ways of dealing in a free society with pigs, but you oink at them. If a professor constantly is doing this, then that becomes an issue of professionalism and has to be taken up by a dean. But it's not because the professor says something offensive, it's because the professor specializes in being offensive rather than teaching. And at that point, it becomes a pedagogical issue, professionalism issue. It's, again, a time, place, and manner. The thing is, the dean could certainly say, why don't you leave those comments for after class? But during class, be a professional. I think that's reasonable. There are standards. I'm not suggesting that teaching should be a standardless profession, but it should allow for the expression of offensive views, minority views, out of views that are out of style. It's a terrible problem today, particularly for conservatives on faculties, who every word out of their mouth offends, arguably offends some people in the class. You can't teach like that if you're constantly worrying about how many complaints today are going to be lodged against you. And it's up to deans to bat these things out of the ballpark and say, I'm not going to start investigations every time I have some student who's offended. When I was in Harvard Law School, I was there for that famous incident of a student who was called on by a professor, a notoriously wicked contracts professor, and asked the question. The student got up and gave a dumb answer. The professor took out a dime, that's what it used to cost to make a phone call, put the dime down on the student's desk, walked back and said, Mr. Smith, go call your mother, tell her you're coming home. Now that would be an actionable offense today. On the other hand, the professor was saying, before you come to my class, do the reading next time. Now, he said it in a kind of wicked way, that was his reputation. But, there's room for that in academia. First of all, it's kind of funny, actually. But, and judges, I can tell you, have said much worse to me, because the professor might have the power to humiliate the student, but judges have the power to hold you in contempt. So you do have to, I have to say, there's something to be said for toughening the skin of law students, because if you appear before a judge, you really find out what it's like to be harassed. And these judges have real power. So I'm not too sympathetic to law students who sit there and wilt every time something is said that bothers them. Particularly law students should not be wilting. Those women in the class at Columbia who found the hypothetical of Professor Fletcher to be offensive clearly should not go into the practice of criminal law. Because the irony is that George Fletcher was able to show that he was basing the exam on a combination of facts in 3 actual reported cases. It really, the thing about the law, when you begin to practice, you will see that it's truth is stranger than fiction. Anything that you can imagine in your deepest perverted thoughts might happen, has happened, and has been the subject of a reported case at least once. Is there another question? I see I'm a little over time already.
If we have time for a quick one.
Yeah.
You mentioned toughening skin, and it does seem to me that this issue, that academic freedom, has in common with many other issues, especially in federalism, a need to control other people because people are pansies. Like they just can't take something that just a little pinprick. And I was wondering if you happen, in your experiences, you come up with maybe like a pop psychology or pop sociology theory of why people are becoming pansies,
Well, I don't think that people today are more delicate than they were 50 years ago or 100 years ago. I don't think it's genetic. I don't think anything has happened to the gene pool. What I think has happened is that there has been a cultural shift. And there is this notion, I think it's political, there has been the cultural shift that says that in order to integrate the society, to better integrate the society, in order to give more opportunities to people in historically disadvantaged groups. And by the way, I don't deny that women are in a historically disadvantaged group. There was a time when they couldn't vote. It's a little hard to deny that's not historically disadvantaged. Blacks were slaves, and they were not allowed into many universities until relatively recently, other than black universities. You can't deny those realities. But to say that in order to integrate these groups, in order to make them, give them an opportunity for success, we have to cater to them as if they're hothouse flowers. It's a huge insult. I will tell you, and that's what it grows out of. I had an incident at Harvard Law School that was one of the most astounding in my career. It was when Coors and I were beginning to think about writing The Shadow University. We had been collecting these stories for 7 or 8 years. And I wanted to test out some of the theses of the book, and so I started to give talks at various Boston area colleges on the subject of these codes, and particularly the theory of the codes, that you had to create a welcoming atmosphere for historically disadvantaged students, and what was wrong with that. Not only in terms of free speech law, not only in terms of this nonsensical sensitivity training thing that was initiated, but also just in terms of how demeaning it must feel to a student to go into class and know that people are not saying things because of fear of offending him or her. It's got to be damaging to the psyche of a black student or a woman to know that. I don't see how it couldn't be. So I started talking about this, and I was invited to give a talk to the student ACLU group at Harvard. My view, by the way, is not necessarily held by all ACLUs. It's hotly debated within the ACLU. It's one of the reasons we started FIRE, because FIRE takes on all these cases. ACLU, some of the local chapters are wishy-washy, some are not. So I gave the talk, and it was a Q&A. One kid gets up, he was a 1L, obviously from Long Island, I can tell the accent anywhere, and he says, Mr. Silverglate, I'm not saying you're a racist, but, and I knew what it was, but don't you give aid and comfort to racists, right? Because you approve of the free speech rights of racists, blah, blah, blah. But before I could answer the question, a black student jumps up, and he looks at this white student, and he says, look, I was born and raised in the South Bronx. You don't know what the South Bronx was like back 30 years ago, 35 years ago. I said there were bullets flying back and forth in my block. It was true. It was like a jungle. Every day, I was snatched out of this neighborhood and sent to a good school by a philanthropist. And I did well in private school. I got into good college. I did very well in college. I got into Harvard Law School. I'm now about to graduate. I've got only 6 months to go. And are you telling me that I'm sitting in a class or I sit in the lounge and some student calls me a nigger? I'm gonna go to my dorm, pack up my bags, and go home in order to nurse my wounds? He said, fuck you. And the white student was sitting, you could tell, completely devastated. He didn't have anything to say because the nature of this demeaning attitude toward the black student that he had inadvertently demonstrated suddenly came home to him. And that I didn't have to answer the question as to whether I was giving aid and comfort to racists. Everybody in the room understood the destructive nature of this kind of pandering. I was convinced at that point that, of course, I had to write the book. Thank you. You've been a great and active audience, and I really appreciate it. Thank you very much.